So we'll start with the topic, okay? So Transfer of Property Act. Last class we discussed about the essentials regarding transfer of property, right? What essentials we need to satisfy in case we are transferring a property, right, from one person to another. Now, Transfer of Property Act talks about different types of transfers, right? So all those different types of transfers are again included like separate topics in your syllabus. So we'll start with sale. All right. Now, sale also some provisions, right? You would see that these provisions are similar with what we discussed in transfer of property in general, right? Essentials for transfer of property, what all things we need to satisfy. So few provisions you are going to see that they are similar. Few more additions will be there. Then we have essentials for all these different types of transfers that may take place under Transfer of Property Act 1882. All right. So if we talk about these sections, right, it has 4 sections. Today we are going to cover 2 sections. In tomorrow's class, we will discuss the remaining 2 sections plus few questions with regard to it, right? Like some MCQs, what may be the probable questions. Otherwise, if it's included in your mains also, you will be able to answer the questions from this discussion, right? Because the topics are being covered here, so you will be able to frame your answers from that part, right? So today we'll start with sale under Transfer of Property Act. So what is Transfer of Property Act? Again, if you are writing an essay type question, right, you can briefly tell about the legislation also, right? That it's the legislation that talks about all these transfers of property. And then there are 137 sections. They are divided into 8 different chapters, like what we discussed in the first class, right? From there, you can extract some intro part and then you can insert that. All right. So Transfer of Property Act came into existence in 1882. Then under these 8 different chapters, they are talking about different things. And under chapter 2, right, sections 54 to 57, it mentions regarding sale, right? So these sections you can remember as well as the chapter, because many a times, right, for MCQs, you have these sections that they are asking, like which section defines sale or under which section provisions regarding how a sale may be effected is being provided, right? So few important sections here and there we need to remember it. Otherwise, provisions are not that complicated, right? It's simple provisions only. So with regard to sale, it's chapter 2 and sections 54 to 57. All right. So anyone remembers what was there in chapter 1 of Transfer of Property Act from previous classes? Chapter 1, like this is from chapter 2, right, that we are discussing.
No, this is the essentials of sale. Sorry, transfer.
It is that first day what we discussed, right? Second day we discussed regarding essentials. So those are basically extracted from different types of transfers that we see, right? Like what all are the common provisions from all of these? Sale, lease, mortgage, gift. Those provisions we discussed basically second class. First class what we discussed, right? Like the applicability, then that Indian Contract Act provisions should apply, right? Then there were some interpretation clauses. Those are the first thing, right? That is like the preliminary part. We have sections 1 to 4. That is the first chapter. All right. And chapter 2 is, there are different provisions that we would also see. But today's thing is from chapter 2. It is these 4 sections that talks about sale. All right. Now, sale of immovable property as given under chapter 2 of the Act, there are 4 different sections which we have. All right, today we are going to discuss section 54, which provides for definition of the term sale, how sale can be made, and contract for sale, right? These 3 things are provided under one section 54. Then we have section 55, which provides for rights and liabilities of buyer and seller. Okay, so these rights and liabilities are going to be a common thing that we will see, right? For most of the different types of transfers, both the parties would get some rights, both the parties will have some liabilities, right? So these things are going to be common, you will be getting it. So these two sections we will discuss today, right? Definition, how a sale can be effected, contract for sale, rights and liabilities of both the parties. Then these two sections we will be discussing in tomorrow's class, all right? So what is sale? In general, when we say selling something, right? What is sale?
Giving out the possession
Giving
of the property.
Giving possession of the property. Yeah. So there are two concepts, right? Possession as well as ownership, right? So in case of possession, what it is, you have almost all the other rights, but you are not the owner, right? So it is said that possession is like now 9 out of 10 points. That means you have almost everything, but you are not the owner. But in case of sale, you are also giving ownership, you are also giving possession, you are giving almost all the rights that you have, right? So regarding sale, it is section 54. Property can be transferred through different modes, that is through sale, mortgage, lease, gift, exchange, etc. And under section 54, chapter 2, we have how property may be transferred by way of sale. So it is defined as transfer of ownership of a property in exchange for a price paid or promised, or partly paid or partly promised, right? Now these things from the definition is very important, from where again MCQs are being asked, all right? So you can like note down the important points. What is sale? Based on the definition provided under section 54, it is transfer of ownership of a property. We are not simply giving possession. Yes, we are giving possession also, but as well as along with that, we are also giving ownership. That means we are giving complete rights over that property. Ownership of a property, one person is giving to the other, but for what reason he is giving, right? Or what is the consideration that the other party is getting? So what is consideration? It will be in exchange for a price, right? It will be some amount that the person will charge. So this amount is the consideration, right? So in exchange for a price paid or promised, or partly paid or partly promised. That means you can pay the entire amount at once while transferring the property in your name, or you may promise to pay the entire amount at a later stage. At the time of transfer, you are not paying anything, but you are simply making a promise to pay it. Or it may be you partly paid it, and for the remaining part, you have made a promise, right? So it may apply in either case, but what you are getting in return has to be in terms of money that we are like buying the property, right? What we say consideration under Indian Contract Act, right? So consideration has to be in terms of money. We are not concerned with mode of payment, right? Sometimes it may be just a promise, like I'm not giving you a, maybe I'm not giving you a check, but I have just given you like a promissory note. That also would apply, right? Whatever it is, maybe there is a promise or there may be direct payment. What is promissory note? Do you remember studying that anywhere? Promissory note? Anyone remembers? It's also there in your like entire judiciary syllabus.
Promissory note is basically the wordings or a spell that is being given by one individual stating that he would be making a payment in future.
Yes. So where do you get that provision?
Contracts.
So it is negotiable instruments.
Negotiable instruments.
Yes. Negotiable instruments, right? So that also would be included if you are making a promise. There is another instrument that is included there? Do you remember that? Promissory note and promissory note is there, and check is also there. One more is there. Yeah, bills of exchange. Yes, right, bills of exchange. So those may also be applied here, that the person is like making a promise that I will be making the payment at a future date, right? So this is the basically the definition which is being given, that you are transferring ownership. It may be in exchange of complete value, complete price, or it may be that you are promising to pay the entire amount at a later stage, or it may be that you are partly paying it or partly promising. So in either case, it will apply. Now, how a sale is effected, how you will get the sale done, right? So section 54 lays down the manner, right, in which sale of immovable property should be effected. How you will get the sale done, that also is being mentioned. All right. In case of tangible immovable property, tangible and intangible property we discussed, right, in the first class. What is tangible property and intangible?
Any property that is in existence and which can be felt and seen, or
Yes.
which is that is tangible.
Yes. So in case of tangible immovable property of value ₹100 or upwards, or in case of reversion or any other intangible thing. So what is intangible? You cannot touch, see or feel it, but it still exists. Like reversion. What is reversion? Take for example, I have a property. I am giving that property to someone on mortgage, right? Even if I'm giving the property on mortgage, I will still have a right to get back the property, right? I can again reverse the transaction, right? Once I make the payment, I can again get back the property. So that right is nothing but reversion. So you cannot basically see that right, but it exists, right? So that would be a tangible thing, right? So it may be tangible immovable property of ₹100 or upwards, or in case of reversion or any other intangible thing. A sale can be made only by a registered instrument. Registered instrument is mostly needed only when the tangible immovable property is of value less than ₹100. Then in that case, the parties will decide how they want to proceed with it. They may either get the instrument registered, or simply by way of delivery of the property also the transaction would take place. Basically, option is given to the parties in that case. The delivery of a tangible immovable property is said to have taken place when the seller places the buyer or any other person on the direction given by buyer in possession of the property. The moment you allow this other person to enter and stay in your property, that time only this transfer of possession will take place, right? You may be giving it to that person, or you may be giving it to someone else on that person's behalf, right? Like a person may buy a property, but he do not want to stay there, only for his family members he is buying, right? Maybe he wants his parents to live there. In that case, you will have to give possession to his parents, right? Whatever it is, you can accordingly give. But what will happen in case you have bought the property on papers, it got transferred and everything, but the person is not vacating the plot. He is not allowing you to enter the property or enjoy it. What can you do in that case? You paid the entire money maybe, or you are ready to pay the money, but this, like, the transaction is being completed on papers, but the person is not vacating the plot. He is not allowing you or any other person to take possession of the property. So what can you do in that case? So you can ask. Yeah.
I'm not sure it can be like you can approach the court requesting for the declaration of the property, or an eviction suit can be filed. I'm not sure about it.
Yes. Injunction basically you would file because it's already declared only, right? You are only the owner based on whatever documents are available. So yeah, court may pass an injunction order that you need to hand over possession to so and so person. Accordingly, you can claim the property. So you can, under specific relief act, you can ask for that relief. So that's a very common type of a relief that is being asked, right, on these grounds. So how sale is affected, that is the provision. And anyways, otherwise also if there are some rules or regulations applicable, you accordingly need to obey those rules and regulations also, right? These are the basic things which we will have to follow, whatever is the formality, right? And accordingly we can get the sale done. Now we have essentials of a valid sale. In what all cases we will consider that whatever sale has taken place, that was a valid one, right? So there are 4 essentials that we need to satisfy for a sale to be valid. So what are these 4 essentials or 4 conditions? First of all, the parties to the sale. There are 2 parties, buyer and seller. So both these 2 parties should be competent to transfer or to take the transfer, right? Subject matter of the transfer must be transferable immovable property. Consideration for the sale must be paid, promised, part paid or part promised. This is coming from the definition only of section 54, right? Mode of execution of sale. So these are basically 4 essentials that we need to satisfy with regard to a valid sale. For the sale to be considered as valid, we will fulfill these 4 conditions. So what are these conditions? First of all, it says the parties to the sale. There are 2 parties, buyer and seller, and both of them should be competent to transfer the property and accept the property also, right? So in sale, there are 2 parties, seller plus buyer. The transferor of the immovable property executing the sale is known as seller. Who is getting the property transferred? He is the transferor or the seller. The person who receives the property or the transferee is known as the buyer, who will receive the property. The seller must be competent to contract and enter into the transfer and entitled to the transferable property. So whoever is buying the property, that person must be competent to contract, because sale is also nothing but a type of agreement or a contract only. So parties should be competent to contract, and also they should be entitled to the property. They should be someone who is entitled to receive that property. So any example you can think of what is entitled to property, entitled to transferable property. So the person, right, to whom you are selling, the seller, the other person, the seller must be competent to contract and entitled to transferable property. That means you should be having valid, like you should be the owner basically, right? You should be entitled to transfer it. If there is some court case pending and you are not entitled to sell the property unless and until the case is being settled, in that case, you won't be entitled to sell it, right? So you must be competent to contract, plus you should also be someone who is entitled to get the property transferred. Plus, whoever is receiving the property, that person also should be someone who is entitled to receive the property. Okay, sometimes it may so happen that in tribal areas and all, right, there are certain restrictions with regard to their properties also. Like in Meghalaya and all, right, you cannot simply go there and say that, yes, I'm buying this plot of land. Outsiders cannot buy a plot of land there, right? Only to the local tribal people only they can sell. So in such cases, if there are such kind of rules or regulations, you need to be someone who is entitled to buy that property also, right? You need to be from that particular tribe or community only, so that you are entitled to buy. You should not be someone outsider, right? So those conditions also need to be satisfied, whatever rules are applicable. Okay. Seller must not be a minor, should be of sound mind, and shall not be disqualified by law to transfer the property. Right? So these are again few other conditions, that the seller must not be a minor, because under Contract Act we have seen that minor is not entitled to like enter into a contract, right? There are cases also which we see that, okay, minor was getting a certain property transferred, right? Like I think there was one case where minor tried to enter into the contract, and his like the mother said that no, this person is a minor, he is not entitled to sell it, so you just get the document cancelled. Like that, there are so many cases, right, where these provision apply. So what happens is, whoever is selling, that person should not be a minor, he should be of sound mind, and shall not be disqualified by law to transfer the property. Otherwise, court will consider that transfer to be void, right? It will not be applicable. And also you cannot held the minor liable. Like if you are aware that this other person is a minor, still you went ahead and entered into the contract, court may say that yes, you are not even entitled to whatever advanced amount you had paid. Also, the minor is no, we cannot ask the minor to perform the contract also, right? So in that case, this party would be on the losing side, who is entering into a contract with a minor even after having knowledge, right? But there was another case where the person was not aware, basically minor tried to misrepresent his age. So in such cases, court would try to apply these principles of justice, equity, and good conscience, like we saw in the first class, right? So by applying those principles, court may still provide a relief to the person, right? That we cannot allow a minor to just take advantage from people just because he is having that immunity, that minor's contract will be void. So accordingly, court will decide the matter. But in general, the seller must not be a minor. He should be of sound mind, shall not be disqualified by law to transfer the property. So when we say this word, right, should not be disqualified by law to transfer the property. This disqualification may come from any law, rules, regulations, etc. Right? It may be coming from like a relief, right? A relief that is granted by court while the case is still pending. Right? Temporary relief is being granted that for this duration, the property will be as it is. You cannot do anything with regard to it. It may be coming from some customs or local usages, that from this specific area, property can be sold only to people belonging to a certain tribal community, right? Whatsoever it is, that will be applicable, right? So that is, should not be disqualified by law to transfer the property. Then the transfer should either be made by the owner of the property or a person authorized to dispose of the transferable property which is not his own. So in what cases it may apply? That owner is not selling, but someone else is selling. Because like property is like a big thing, right? It involves so much of money and value. So who can be authorized and how the person can be authorized to sell?
Is it Benami transaction, ma'am?
Benami transaction, how?
Like if it is not the owner, like if any person acquires the property and sells to another person, keeping like in a wrong possession.
Not like that. Benami would be like government is having like authority over it. So you need to basically pay a certain money to make the property like regular. So not Benami, but another example we can take. Okay, take for example, there will be some authorization given, right? It may happen that if there is like these real estate agencies are very popular. right? Sometimes a normal person, right?
Power of attorney.
Yeah, power of attorney, right? We can give power of attorney. Like we can go to a real estate agency and we can give them authority to sell the property on behalf of us. That also may apply. Then power of attorney is also very popular in case of these apartments, right? Take for example, there is a person who is having like a big plot of land and he sold that area to a builder. Now builder is constructing like 3-4 blocks, big apartment, and he has said that I'm giving 5 flats to the owner, right? Now, after the construction is done, right, owner may say that I'm not interested to keep these 5 plots. What you do rather is you sell these 5 plots also on my behalf. In that case, builder may, like the owner may give power of attorney to the builder and builder will sell it. So in such cases also it would be valid only because this person is giving authority, right? So transfer should be either made by the owner himself or it may be done by someone who is having authority to get it done, right? In such cases also, we would consider it to be a valid one only. The transferee should be competent to receive the transfer and he shall not be disqualified by law to receive the property transfer. Again, same that tribal laws would apply, right? If there is a tribal community and there is a norm that you cannot sell it to someone outside, then you need to be from that community to be able to buy it, right? So this is the first essential which we have, that the parties to the sale, both buyer and seller, must be competent to transfer. Basically, they should be competent to enter into a contract based on the provisions of Indian Contract Act. Apart from that, if there are any rules, regulations, etc., they should they should satisfy all those provisions as well. Next essential is the subject matter of the transfer must be transferable immovable property. What is the property that is in question? That should be a transferable immovable property only, right? It should be something that we can transfer. When a property is transferred with an intention to sell it to the buyer for a consideration. Consideration is price in this case. The transfer of property includes the delivery of property along with ownership rights of that property. Yes, we are giving possession of the property. You are entitled to hold the property, plus we are also giving ownership. Immovable property can be tangible or intangible, like a right of reversion, right? It would be intangible and it can be tangible as well. Now, under Section 6, a property of any kind may be transferred except the following. That means there are certain specific types of properties mentioned which cannot be transferred. Apart from that, other properties we can transfer. So when we are talking about transfer of property, we need to satisfy this condition as well, that it is not coming under any of these grounds. So what are these grounds? First one is a transfer of spes succession. So what is this spes succession? It basically is a Latin maxim, which means the chance of succeeding in a person's property after his death. So based on the succession rules, if a person knows that, yes, after death of this person, I am only going to, get possession of this property. Property is going to get transferred to me. But that thing I cannot transfer. I cannot be like, okay, fine, it would get transferred to me, but I don't want the property, so get it transferred to my friend. That would not happen. Based on the succession rules only, it would get transferred. So a transfer of spes succession cannot be transferred. Whoever is having the right, that person only will be able to enjoy that right. That right cannot be transferred to someone else, right? And these conditions are mentioned under Section 6 of the legislation. Then right of re-entry. I guess these we also discussed in the second class, right? While discussing about essentials of a valid transfer. So what is right of re-entry? If someone is filing a case that I had the right to enter this property, but that right is being restricted. So I should be allowed a right to re-enter the property. That right also is like a personal right. If I had that right of entry, I only can enjoy this right of re-entry. That will not be given to some other person. Similarly, easement, right? Easement is like someone else is having a right to enjoy or enter some property. That right also, whoever is having that right, that person can only use, someone else, it cannot be transferred. Interest restricted to personal enjoyment, right? If there is certain interest which has been restricted, that only this occupier will be able to enjoy this thing, only he should be able to enjoy. He cannot transfer it to someone else. A right to sue. If your right is being violated, only you can file a case. You cannot get it transferred to someone. Similarly, public office. If you are holding some public office, you cannot get the office transferred because obviously you had appeared for some interviews and stuff. You hold some qualification. That is the reason why you are holding the post. It cannot be transferred to any other person unless and until that person also qualifies those grounds. Pension or stipends. You cannot directly say that I don't want this pensions or stipend, get it transferred to the other. You need to accept it. After that, you donate it, give it, whatever you want to do, you will be able to do. Opposed to the nature of interest. Whatever is mentioned under Indian Contract Act regarding like contracts, contracts specifically declared as void, right? Those provisions would apply here as well. If there are certain other grounds or conditions which says that these things should not be present, like you should not make a contract or make an agreement to deceive someone, right? Or to, like with a guilty intent, with some unlawful consideration, those things again would apply here as well. Statutory prohibition on transfer of interest. If law has established certain restrictions, those also would apply, right? If based on the custom or usages, it is mentioned that this like immovable property of this certain state cannot be transferred to any outsider, that again would be applicable, right? So that will be like a statutory prohibition on transfer. Otherwise it was transferable, but now based on a certain statute, there are certain restrictions being imposed. Accordingly, we need to follow that as well, right? And then there was this case which I guess we discussed last class also, that if you are willing to get some money by way of mortgaging your property, right? In that case also, you should be having rights to mortgage the property. You cannot mortgage a property only based on the condition of spes succession, right? You should not be like, okay, fine, anyways, after death of this person, I am going to inherit the property, so now itself I'm mortgaging the property. That would not be allowed. Only once the property gets transferred, you will be able to use it or put it for mortgage and stuff. But before that, only on the condition of spes succession, you will not be allowed to do, right? Those kind of agreements would be considered as void. So these are basically the types of properties or types of rights which we cannot transfer. Otherwise, we will be able to transfer our rights or other stuff. This part, is it clear? Is this
Yes.
So these were the two conditions. We have like 4 conditions, right? So what are the remaining conditions which we have? It says the consideration. The consideration for sale must be paid, promised, part paid or part promised. What is consideration in case of sale? It is money. So money may be completely paid, completely we are promising, part we are paying, and for the remaining part, maybe there is some promissory note, maybe some check issued with like a like forward date, right? It might be I'm putting date of January 2022, right? Like that also I may do. Those also would be valid. Similarly, part promise, part pay. This is clear only, right? From the definition it is coming. So if we are getting a property transferred without a consideration, that will be considered as gift. But here we are concerned with sale only. So it has to be transfer of property. Consideration will be in terms of money. Otherwise, it will become exchange of property for something else. Now, there was one case also where court held that payment of consideration is of the essence when transfer of property is made through sale. The time of payment of consideration is not material. Consideration may be promised or paid at a future date also. Like it is coming from the definition itself that what is the time when you are making the payment is not relevant, but we are concerned with the fact that consideration has to be in terms of money, right? So this is the third condition that we need to satisfy for a valid sale. Fourth one is mode of execution of sale. So what is mode of execution? What is execution?
Completion of sale, ma'am.
Yes, completion of sale. If we are wanting to get a sale done, what is the mode by which we can get it done? So a property must be transferred by sale. Like this provision again same, right? Like registration is needed, or if it is less than 100 rupees, it depends on the parties. If they want to get it registered, get it done. Otherwise, simply by delivery also they can do. So like that, whatever provisions are there, right, regarding witnesses and all, or any other provision whatsoever applies from Transfer of Property Act, Registration Act, or might be some local laws, usages, all those formalities we need to satisfy, and accordingly we will get the transfer done, right? So mode of execution of sale is nothing but whatever formalities apply to your specific property based on from where you are transferring, those formalities we need to satisfy in order to make it like a valid transfer, right? So those are the, all right. So those were the 4 conditions for valid transfer. Now there is another concept, difference between sale and contract of sale. So what is the difference between sale and contract for sale? So sale, when we say, right, it is the entire process, right? Once the process is completed, it would be called as sale. But contract for sale is like when they are still in that process of getting the property transfer, that is nothing but contract for sale. So what is sale? Sale of immovable property is a transfer of property along with ownership rights. We are finally transferring the property by giving possession of the property plus transferring ownership rights. In case of contract for sale, what happens? Contract for sale is a mere agreement that a sale of a property is to take place in future on the terms mutually agreed between the parties. The ownership rights remain with the seller. That means they are still in that negotiation process, or maybe they are still getting the property transferred, right? Finally, the registration has not yet been done. During that stage, we would say that there is a contract for sale, but this contract for sale is not yet being completed. So that is the basic difference. Sale is when entire process is completed. Contract for sale is when we are still in that process of getting it transferred. In a sale, the seller transfers the legal title of the property to the buyer. Whatever title right I had, this absolute thing I'm transferring to the other person. But in case of contract for sale, no interest or charge is created in favor of the buyer, because we are still in that process of getting it transferred. It's not yet being finalized. That is the another one. Next one is sale creates a right in rem. Contract for sale creates a right in personam. So what is the difference between right in rem and personam? Anyone remembers? From jurisprudence concept of rights.
Right in rem is the right against the word, ma'am, and right in personam is right of an individual person.
Yes. So what will be the right in case sale is completed? What right we have against the entire world?
Right in rem, ma'am.
Yeah, so under that, what all we can do?
Once the sale is completed, we have all the rights over the property and can enjoy the property and also have the right to resell it, sell it further.
Yes. So in case of sale, we have a right in rem. Apart from us, whoever else is remaining, they all have a duty to respect our right, right? That they cannot just enter our property, it would be trespass. They cannot disturb in our enjoyment, it would be like nuisance and other stuff, right? We have complete right, we can do whatever we want with regard to the property, sale, mortgage, gift and other stuff. So when we say right in rem, it gives us a right to enjoy the property to the exclusion of the entire world. But in case of contract for sale, it only creates a right in personam. Because I am in discussion with that seller, so I can only ask the seller that I already wasted 2 months of my time in this entire negotiation, like this process of negotiating with you. So you get the property transferred in my name. Right? Like that, I can ask only this person that yes, you get the property transferred to me. Right? But I cannot ask someone else. Right? I may say that I already paid the advanced amount, so you get the property transferred. So this will be right in personam. Only against the owner or the seller I will be able to enjoy that right. But in case of sale, it is like absolute. A sale must be executed by a registered document where the immovable property is of value ₹100 or more, or in case of reversion or any other intangible property. So whatever is the rules or regulations, we will follow it. In case registration is needed, we will get the registration done as well for the transfer to be considered as valid. But in case of contract for sale, it does not require registration because we are still in the process of getting it registered, right? Still in the process of getting the deal finalized. So these are basically the differences between sale and contract for sale.
Just I wanted to see the last point.
Yeah.
Just I was noting it. Yes, ma'am.
Yeah.
Thank you.
So that was all about section 54, right? So definition as well as how sale can be done and other stuff. Now we have section 55 that provides for both rights and liabilities for seller as well as the buyer. So it mentions in the absence of a contract to the contrary. That means unless and until you have a specific contract providing for specific rights or obligations, it will be assumed that your rights and liabilities are as mentioned under section 55. Whatever rights and liabilities are mentioned under section 55, you will accordingly be made liable unless and until you have made specific provisions in your agreement itself. Right? So in absence of a contract to the contrary, the buyer and seller of immovable property are entitled to whatever rights and obligations are being mentioned under section 54. So what all rights and obligations do we have? First of all, we have certain duties of seller. So what are duties of seller? Firstly, to disclose the buyer regarding any material defect in the property, right? If there are some defects in the property which the buyer would not be able to understand through his normal, this ordinary care, right? Like before a person goes on to purchase a property, he will visit the property and do his own bit of investigation, right? So if the defect is something which cannot be identified through that ordinary care or ordinary this investigation that people would do, in such a case, seller is having a duty to disclose it, right? Maybe if the property is, like a Benami property, and might be this buyer is someone who, like is not having that much of knowledge. He simply said, okay, fine, title deed you have, I want to buy it, right? In such cases, maybe he will have to tell. If there is some, like other defects are there, right? Might be with regard to his ownership, someone is claiming, right? Like on papers, the property is in his name only, but someone else is also claiming, and there might be a legal dispute regarding it. So those defects he need to tell to the other party with regard to the property. Secondly, to produce to the buyer on the request of the buyer for examination all documents of title relating to property. Like before buying property, people would usually go to a lawyer and get the documents verified, right? For document verification, they would go and tell, hey, please check if all the documents are proper or not. Can I proceed with this transaction or not, right? So apart from doing that, they would also ask for various like certified copies. Like we have this red RTI, they would file RTI, right to information application, maybe to the registrar office, to taluk office, village panchayat, whatever it is, right? And they will provide, this is the survey number of the property, this is the khata number, this is the address. Please tell me who all are the owners, who is the latest owner, how he got the property transferred to his name, when he got, are there any pending charges regarding this property? All those things they can ask. Right now, to ask for all those things, prospective buyer would need certain information, right? Prospective buyer would need to know the khata number, survey number, address, under which registration office it is coming. Those details should be provided by the seller, right? And whatever documents are needed, those also will be supplied. Like buyer may want to get certified copies of certain documents. In that case, those also need to be provided to him, right? And accordingly, buyer would get it done. This would also apply in case of apartments and all. Buyer may say to the builder that, okay, have you applied for occupancy certificate? Did you get it or not? Please give me a copy of the OC. They can verify that copy, right? Please give a certified copy of it. So these steps are taken in order to see that this property is like a good one only that he is buying, right? So for examination, whatever is needed, those details will be provided by the seller, and accordingly, buyer will do his own bit of investigation. To answer to the best of his information, all relevant questions that are being raised by the buyer, right? So buyer may ask certain things like, have you paid the property tax or not? This, that, all those details need to be provided, right? So whatever are like a reasonable question, those will be provided by it. So like buyer would not be like, okay, fine, tell me, can I grow this vegetable here or not? Those would be not like reasonable. Whatever is relevant, reasonable question, to the best of his information, seller will try to answer those questions. On payment or tender of payment due in respect of the price to execute a proper conveyance of the property, right? The seller will initiate the process, right? Seller will initiate the process of getting the property transferred through preparing the sale deed and everything. Once he has received the payment, maybe, or the tender and other stuff, once it is like finalized, he will initiate the process to for execution at a proper time and place. Accordingly, he will initiate the process. Between the date of the contract for sale, right? When they are still in that negotiation process, getting the property transferred and stuff, and delivery of the property. Between that duration, whatever time period they are having, during that time, seller will have to take care of the property plus all the property related documents, just like he would have taken care of it if it was his documents, right? So like how a normal prudent person would take care of it, they will have to take care of it like that only. So they should not be like, okay, now transfer is done, so let the documents be lying here only and it may get damaged. So they accordingly need to take care of the property plus the documents until possession is being transferred to the person, the buyer. Next one is to give, on being requested by the buyer, possession of the property as its nature admits. So it's not just like on paper you are getting the property transferred, but also you need to hand over possession to the other person so that the other person is able to enjoy it. So accordingly, when the transaction is completed, you need to accordingly give possession of the property, maybe to the buyer, or it may be maybe buyer's family or someone else, right? Relative, whomever they are saying, you accordingly need to get the property transferred to that person. Next one is to pay all public charges. Now, what is public charges? It may be some payment which you need to pay to someone else. It may be some property tax or some other payment, right? Whatever public charges are pending or other like payment with regard to the property, right? Up to the date of sale, till the date when the sale gets completed, it gets registered, whatever pending payment was there, you need to make that payment. Whatever dues are there, everything you need to clear it out, right? To discharge all of those things from the property that it is existing before you hand over the property. Till the point sale is being completed, whatever pending charges and every liability and stuff you had, you need to clear all of that. Then you transfer the property. Right? But there may be certain cases where a seller may clearly disclose that yes, there are these few charges which are pending, and what you can do rather is you can clear those amount on my behalf, right? If there is an agreement between buyer and seller that buyer will be clearing those pending payments, that also can be done. Buyer will say that, okay, fine, we agreed to pay you this much, but I will be deducting those pending public charges, and accordingly also they can proceed. Like if you are disclosing it, there is an agreement, that's fine. Otherwise, you clear all the pending charges that are there. Next one is where the whole of the purchase money has been paid to the seller. He is also bound to deliver to the buyer all the documents. Once the entire payment is being completed, you also need to hand over all of the documents relating to the property because you are no more the owner. So you get all the documents transferred to the buyer. But there may be a situation where it's not just one person who is buying from you, right? Maybe you have like a big plot of land and there are a lot of owners who are buying. In that case, individual documents you would give. Whatever is the main document that you may give to the person who is holding biggest area of land, right? And whoever got those documents, right, that person will have a duty that he will like make it available for the other persons whenever needed, right? So those liabilities and obligations should be there. Otherwise, when the entire payment is cleared, you need to hand over all the documents to the buyer, right? But there may be a case where the seller retains any or part of the documents compressed in such document. He is entitled to retain all of them. If there are two or more owners, then to whom it would be given, right? Those additional rules may apply, but otherwise, once the sale is completed, payment is being done, the process is completed, you need to hand over all the documents to the buyer. Okay, so these are just the exceptional cases where if you are selling it to more owners to whom you would deliver regarding that. So is this part clear? Any point you want to be repeated? Duties of seller? All right, so those were duties of seller. Then we have certain rights that the seller will be having. So what are his rights? He is entitled to rents or other profits of the property till the ownership is passed to the buyer, right? So till the moment the registration process is getting done and other stuff, during that stage also, whatever profit, rent and other benefits are arising, the seller is entitled to all of that as well. So he will be entitled to the benefits plus he will be liable for the obligations as well. Where the ownership of the property has passed to the buyer before payment of the whole of purchase money. Sometimes it may happen that you have only promised to pay half of the money or promised to pay the entire money, but even based on that promise only, property is being transferred, right? So in case where ownership of the property has passed to the buyer before he has actually made this complete payment, in that case, to a charge upon the property in the hands of buyer, any transferee without consideration or any transferee with notice of non-payment for the amount of purchase money or any part thereof remaining unpaid and for interest on such amount or part from the date on which possession has been delivered. So in case property is being transferred before the entire amount has been received by the seller, seller will still have a right to get back all of that remaining payment which is lying there, right? And with regard to that, some interest if it is applicable, that also seller will be entitled to receive. But before he gets all of that, he may still like transfer it, right? Transfer possession of it to the buyer, but that does not mean he has like waived off his right, right? Those rights will still be applicable to the seller. He can accordingly get it done. So for rights of seller, we just have two different rights, but obligations are more, right? So many obligations, just two rights we have. Then we have certain duties with regard to buyer also. So what are duties of buyers? To disclose to the seller any fact as to the nature or extent of seller's interest. That means there may be certain facts which the buyer is aware, but seller is not aware, right? And these facts are of such a nature that it is of interest of the seller. That means if seller comes to know about those facts, maybe value of the property would go up, right? If there is any that kind of fact, right, or information, buyer will have an obligation to disclose that to the seller, right? Like take for example, if there are some hidden minerals or something in that plot of land, right? So in such a case, if buyer comes to know about it but seller is not aware, buyer needs to disclose it, because in that case value of the property would go much higher, right? In such cases, buyer should not be like concealing that fact and simply just purchasing that. So that is like a duty of the buyer. He should disclose all of those facts which he comes to know is of such a nature that value of the property would be increased and it is of interest of sellers. That is the first duty or obligation which the buyer will have. Secondly, to pay or tender at the time and place of completing the sale the purchase money to the seller or such person as he directs. It might be the seller who is coming there to get the transaction done, or it may be his legal representative or someone, whoever it is, buyer will have an obligation to pay the purchase money when the property is being transferred to that person on papers, provided that where the property is sold free from encumbrances, the buyer may retain out the purchase money. Out of the purchase money, the amount of any encumbrance on the property existing at the date. That means if there are some, like we saw, right, that seller needs to clear out all the public charges which are due, right? If there are some public charges, any liabilities or any other thing which is not cleared by the seller, but property is getting transferred, in that case, buyer may deduct that much of value from the purchase money, right? From the price for which he is buying the property, he will have a, like this thing, right? That he can deduct that amount, and remaining amount he will have an obligation to make the payment and shall pay the amount so retained to the person entitled thereof. When it is getting transferred, you accordingly need to make the payment regarding purchase money as well. Third one is where the ownership of the property has passed to the buyer to bear any loss arising from destruction, injury, decrease in value of the property not caused by the seller. Right? Once the property has been transferred to you, right? After that, even if just it got transferred next moment also, whatever loss, destruction, injury, etc. is arising in the value of the property, right? Which the seller has not caused, but it is some normal damage that is being caused, you need to bear that also. You cannot say that it was your property, you only take it, I don't know. That cannot be done, but buyer will have a duty to, like deal with those destruction, those things also. I think recently there was one thing shown that there was landslide somewhere, and like there was a house, okay, like very beautiful, nice house just next to the river, I guess, and then entire property just got damaged. Like within few seconds, it just disappeared from there. Right? So those kind of incidents are very common, right? So if the buyer bought a property saying that, okay, fine, this is like a such a nice view and stuff, he paid a lot of money, just next to the, just after the purchase was completed, it got disrupted, property no more exists. In such cases also, he cannot go to the seller saying that you only take back your transaction, I don't want, you give the money. That will not happen because transaction was completed. After that, some loss or something has happened, right? So that would not apply. Similarly, you would see value of property would go up in case there is some news like metro line is coming this way, right? Value of property would go up. If they are saying some, like very reputed hospital will be set up, property value would go up, right? So like that also, if someone buys a property paying higher amount with, like thinking that someday metro line would come, next moment after the person bought the property, news comes that no, government is not going to construct any railway line on this in this area anytime sooner. In that case also, property value would again come down, but the person cannot say that, okay, fine, now you need to return that excess amount or something. Whatever is done is basically done, right? That is again a duty of buyer, that buyer will have to deal with any sort of loss, destruction, injury, decrease, etc. that may be arising to the property. Next one is where the ownership of the property has passed to the buyer as between himself and seller to pay all public charges and rent which may become payable in respect of the property, the principal monies due on any encumbrances subject to which property is sold, and the interest thereon after accruing due. So what happens is, in case you bought the property along with certain pending public charges or some other liabilities, right? If you said that, yes, I'm going to pay, I'm going to clear those liabilities, in that case, buyer will have an obligation to clear those amounts as well, right? If some property tax was pending, all right, and accordingly seller also said that, okay, fine, this much of rupees is the property tax, you deduct it. It was deducted. But buyer is delaying it, as a result, some fine and other stuff is being imposed, right? Like late fee and all. In that case, he would be liable for that also. Whatever, based on whatever terms or conditions he bought the property, he need to clear all of those terms or conditions also, right? So whatever was already pending, those he need to clear, plus whatever would come in the future date, right? Whatever other charges he needs to pay regarding the property, those also the buyer will have an obligation, right? Buyer will have a duty to clear those payment as well. So these are 4 duties that we have, duties of buyer, right? 4 duties. Is this part clear? Any point to be repeated? So 4 rights we have. After the sale is completed, buyer will have to take complete ownership. He will be responsible for whatever good or bad happens regarding the property, right? So 4 duties we have. Next one is rights of buyers. And also these rights of buyers will be kind of similar to obligations of seller. Obligations of seller would be similar to kind of like vice versa, right? It is sort of similar. So what all will be rights of buyers? Where the ownership of the property has passed to the buyer to the benefit of any improvement in or increase in value of the property and to rents and profits. So buyer is having an obligation to deal with any sort of destruction, damage, loss of value, whatever arising. Plus, he will also be entitled. He will also have a right to enjoy the benefits of any sort of improvements or increase in value of the property or whatever other rents or profits are coming in from the property. He will be entitled to that as well. So after a sale was completed, next day only government announces that there will be a metro line in this certain road. There will be 2 universities, this, that, right? And property value in one day only it went up this much. In that case also, seller cannot come back and say that how come you bought the property for such a less price? You need to pay me additional amount. That would not happen, but buyer will have a right to get all those benefits, right? So he will have to deal with the loss also, benefits also. That is his rights and obligation. Plus, he will also be entitled to any sort of rents, profits, etc. Right? There may be some additional benefits that the person is getting. Right? Like there might be some like a tree, right? Like a there may be a tree was there which is having like medicinal value. Right? So whatever benefit the person would be getting from it, that also he will be entitled to use that, and whatever other benefits arising, he is entitled to it. Unless he has improperly declined to accept delivery of the property to a charge on the property as against the seller or other persons claiming under him to the extent of seller's interest on the property for the amount any purchase money properly paid by the buyer in anticipation of delivery, and for interest on such amount, and when he properly declines to accept the delivery also for earnest and for cost, etc. Sometimes what may happen, right? Like the transaction was like in the process, right? Both buyer and seller were in the process of getting the property registered. Might be buyer also paid some advanced amount to the other person, right? So after some advanced amount was paid, they were almost about to get the deal closed. Buyer comes to know that there is some issue with regard to the property, right? Maybe this, there are some defects, right? Might be it's a Benami property or something. In such case, if buyer properly refuses to accept it, that means he is not like, it's not like a breach of contract, okay? There is a genuine reason for him to say that I don't want to proceed with it, right? In such cases, seller will have to return whatever advanced amount and all he had taken, right? So if buyer properly refuses to accept the delivery, seller will have a duty or an obligation to return whatever benefits, advanced amount, etc., that he had taken with regard to it, right? So that also is like a right that if you are getting to know about it, you can file a case, like you can ask for return of those benefits or things that you had already given with regard to it, right? And any cost also that maybe you had paid regarding or suit for specific performance. If you had to file a case in order to get back your advanced amount and other rights, in such a case also, those also needs to be refunded, right? Those also needs to be paid by the seller only because there was some defect in the property, right? So it may happen like these are like an example, okay? So what it says, there is like an additional provision mentioned under this section 55 only. It says, an omission from the part of seller to make disclosures of any material defect in the property or the seller's title thereto, of which the seller is and buyer is not aware, and which the buyer could not by with ordinary care discover is fraudulent. That means when they were in the process of getting the property registered, during that process, suddenly buyer comes to know that this person is not even owner of the property, or this person is just a joint owner of the property. Or might be this is a Benami property. This is, might be he was saying it's an A khata property, but it in reality is a B khata property. There may be so many different things, right? Those were not disclosed by the seller. In such cases, it would be considered as a fraudulent transaction, and the buyer will have this right, right? Buyer will have this right to decide what he wants to do. So this may also come under here if they were already transacting with regard to it, advanced amount paid and stuff. Buyer can ask for return of all of those because he do not want to proceed with such an agreement or such a transaction. Similarly, an omission from buyer to disclose to the seller any fact, like I told you, right? If there is some hidden mineral which may increase value of the property, buyer is aware about it, seller is not aware. In such cases, buyer should be revealing it. If buyer has failed to reveal it while they were about to get the property registered, then seller, comes to know about it, then seller can accordingly say that I don't want to proceed with it, right? So in such cases, whatever will be the benefits taken by parties, that needs to be returned, right? So this is basically the rights which we have. Then there was this case also, Nathu Khan. So there was this case also, Nathu Khan versus Burtunath Singh. So in this case, it was held that if a sale deed contains declaration stating that property is free from any sort of encumbrances, any sort of this liabilities or any sort of obligations or defects, when the property is subject to a mortgage charge, the buyer will be compelled to discharge the mortgage debt to protect his property from the charge holders, which is purchased by him. However, the seller will be liable to pay the money. That means in the agreement, when you get the property transferred, there you will also mention, right, that the property is free from any sort of liabilities, pending dues and stuff. If those were there, you are disclosing it, you may also mention that buyer has agreed to pay it. Accordingly, he will be deducting the amount from purchase money. But if you have mentioned that it is free from any sort of liabilities and stuff, but later on it is found out that this property was on mortgage, in such a case, what will the buyer do? Because he has already bought the property. So buyer can release the property by paying the mortgage amount, but buyer will have a right to claim that money from the seller, right? So that was basically held that in case these sort of facts are being concealed from the buyer, in that case, buyer will have a right that he can release his property to save the property, but later on he can file a case against the seller that these things were not disclosed. So amount again should be paid to him, right? So these are basically rights that we have with regard to seller. And in case you are writing a long answer, you can give some conclusion as well with regard to it. So is this part clear? Rights of buyer, rights, duties, buyer and seller?
Yes, sir.
So this is section 54, all the rights, liabilities, the buyer and seller is given there. So there are few questions that you can try to answer from this part only. Definition of sale is contained in Transfer of Property Act. In which section?
54.
Section 54 of the Act. Yeah. These questions, these questions look very easy when we are discussing it, but before exam, there will be so many sections, right? So that time it becomes a little difficult to remember. So it is section 54 that provides for definition for the word sale. Next one.
100.
Tangible immovable property of value of which amount or upward can be transferred only by registered instrument, 100 or upward only by registered instrument. Third one.
Payment of price in cash, ma'am.
Yes. So parties is needed. Someone has to transfer to someone else. Subject matter is also needed. We need to properly mention which immovable property we are transferring. Transfer or conveyance is also needed. Definitely that is the main reason why we are getting the sale done. But payment may be by any mode. It should not be in cash only. So option B. Question number 4. Transfer of tangible immovable property of value of rupees 100.
See, ma'am.
Which option? Question number 4.
See, ma'am. Delivery property.
Anyone else? Yeah, because it is 100, right? 100 or upward would be by registered instrument. Less than that only can be delivery or by registered instrument, right? So this one will be registered instrument. And also if it was like less than 100 also, they would have mentioned delivery of property or maybe by registered instrument, however parties like. So it will be option A, only by registered instrument. Last one. Under the meaning of section 54 of Transfer of Property Act, sale is a transfer of ownership in exchange for, yes, it may be price completely paid, price completely promised, price completely paid, or like partly paid or partly promised also. Right. So these were few questions from section 54 and 55. We have 2 more sections remaining, plus there are few more questions. So we'll continue with that part in tomorrow's class. Okay. So we'll end this class here then. Thank you.
Thank you.